appreciated or dealt with.
ફરી પૂછે બોલો, ક્વેશ્ચન બોલો ને ફરી પાછો ક્વેશ્ચન છે. હા.
Assuming that I have raised one contention regarding estoppel that has not been dealt with in that decision making.
Speaking to minutes, you will have to file speaking to minutes or review.
No.
That is the only option. Because see, there is a judgment of the Supreme Court. I understand your query that if a particular argument is raised,
yes,
but it has not been dealt with in the judgment,
yes,
then can you raise this point before the appellate court that learned judge has not dealt with? That would not be appropriate proceeding. In 1965, in judgment of Bashruddin Ashraf, the Supreme Court was confronted with similar situation. And it was said that record of the court is presumed to be correct. Therefore, if some judge has not dealt with your argument, the better course open to you is to file speaking to minutes within a particular time. 15 days is the time limit which is prescribed under Gujarat High Court rules. But if you miss that, then you will have to file a review application stating that I did raise this point before this honorable court, but it has not been reflected in the judgment. Otherwise, the record, court being a court of record, its record is presumed to be correct.
Sir, my issue is different. I have raised this issue in written submissions.
Still.
At the earlier stage, and at trial stage, sir, and it has been decided.
The Supreme Court no judgment છે કે lawyers raise many contentions in written pleadings. But if the judge has not considered it in the course of his judgment and you feel it was an important omission, your only recourse is to file a review. Get it?
Sir, what happened in labor? Sir, I want to submit.
Don't argue before us.
No, I am not arguing.
Now it's asked and answered. No. You asked a question, it's answered.
I have been misunderstood, sir. I have been misunderstood. It's a labor court's an appeal has been decided, and now it is before this court. This issue happened. So at initial stage, sir, labor court, I have given this issue in writing, yes, and that has not been dealt with. Principle, they have shown that issue, it's a principle estoppel, but that they have not discussed. They have discussed limitation in that decision.
Rather than a particular case, you ask a question of general importance which is of interest of all. Individual cases would be different and you are only concerned with that. So it's better to generalize your question.
So it can be said as a non-application of mind?
Yes, you can say that it's a non-application of mind. This argument was taken, and labor court, if it has no power of review, you will have to state like that. But so far as High Court is concerned, High Court judgments, being a court of record, they are deemed to be correct and conclusive. Therefore, you cannot argue before the Supreme Court or LPA bench that I have taken this point before the learned single judge, but he has not dealt with. That would not be appreciated.
Right, sir, right.
But labor court, if it does not have power of review, then you can take that this is non-application of being, because it was expressly taken and it was bound to deal with the contention.
Oblige.
Sir, sometimes in reply, I read that though the petition memo says that the petition is filed under Article 226 and 227 both, but actually the petition is filed under Article 227 only. Does court give importance to such replies? That's what I'm trying to.
Actually, my discussion covered almost all these things, but I will answer this. That first of all, you have to decide. Being a petitioner, you have to decide which article would you like to invoke. Article 226 is available in respect of any decision of authority, person or the state government, that as per the specific wordings of the article. If you are challenging the order of the tribunal or court, as per the judgment of the Supreme Court, I am saying, I am not saying my personal view on this aspect. As per the Supreme Court judgment, it will be a petition under Article 227 because they are subject to power of superintendence under Article 227 only. Article 226 does not refer to courts or tribunal. So in Radhesham versus Chabinath, Supreme Court has clearly said that civil courts are not amenable to certiorari jurisdiction. So if any order of civil court is there, you will have to file a petition under Article 226. I have my own reservations about the judgment, but the correct answer as per the law present, this is the answer.
Sir, one question to Asim Bhai. Generally, we are filing the petition under 226 and 227, but we just indicate the some articles 21, 19, and what is objectionable in that. If we include all the articles in the petition, or miss some articles, it makes no difference actually. But if we indicate 226, 227, 21, 19, then what is objectionable?
No, there is nothing objectionable, but when you draft a petition, it must disclose application of mind, that you are aware of what you are demanding and you are not entitled to certain things. If you are challenging the order of the tribunal, as I said, that order of the tribunal cannot violate fundamental rights, that is the principle laid down by the Honorable Supreme Court. So you cannot be oblivious of that fact that Supreme Court has said that order of the tribunal cannot violate fundamental rights. Still you invoked Article 14, 19 and 21.
Yes,
It's better to invoke Article 226 only, seeking quashing of the order, or 227 for quashing of the
But
order. It is not objectionable, but it is advisable, and you must apply your mind before you invoke anything.
But otherwise, we can write 226 and 227.
Not difficult. 226 and 227. Only thing is that it would create complication when you file letters patent appeal.
Yeah, right.
Then it would be difficult whether it was 227 or 226.
But if you indicate both the articles, then letter patent appeal can be entertained or not?
So then ultimately,
That is the question of...
that is a question of interpretation, because ultimately learned judge would say that I had exercised power under 227, then your appeal would be barred. So I would invoke only 226 in most of the cases, unless I am satisfied that this is a case which requires invocation of 227, because 227, just for 1 minute, and thereafter we will have discussion from Mr. Anand, because we would be getting late. Thereafter, if time permits, we will again have an interactive session. 227 is a power of superintendence over the court and tribunal. The best judgment, unadulterated judgment on the scope of Article 227 is the judgment of Calcutta High Court in Dalmia Jain Airways case, AIR 1951. Justice Harris has said that Article 227 cannot be invoked in a routine manner. It has to be exercised very sparingly. It is a power of superintendence. When High Court, being a superintendent, feels that subordinate court or tribunal has exceeded the jurisdiction vested in it, then only it is in the nature of duty. But the invocation of Article 227 is not barred at the instance of private party, but ultimately is the power of superintendent. Court must be, only jurisdictional error can be corrected. That is the correct interpretation of Article 227. All other interpretation which permits raising issue of error of law or error of fact in Article 227 or perversity, they are not actually correct interpretation of Article 227. 227 permits correction of only jurisdictional error. And that has been followed, Justice Harris' judgment in Varyam Singh versus Ramanath, and later on judgment.
Thank you, Asim.
Thank you.
Thank you.
Now we move on to the third one. This is also very interesting topic. The first question that may rise in our mind is that, sir, what have you to do with the jurisdiction of the Supreme Court and the procedure thereat? Because mainly we are practicing in the High Court. But I think our common practical experience is that once the matter is over, either in your favor or against, the client mostly depends upon your advice for pursuing the matter further in the Supreme Court, the nature of proceedings, the procedural aspect. In fact, the very first question that client would ask you, what is the period of limitation for SLP? So it is not a subject with which we are not concerned with. It is equally important and part and parcel of the practice of the High Court. To comment on that, we have with us today the third speaker, Mr. M.R. Anand, a senior advocate and a former government leader, a member of our association, and with his vast experience of, I think, more than a decade in practicing in the Supreme Court, he would enlighten us with regard to the nature of jurisdiction and the nature of practice prevalent in the Supreme Court. May I request all of you to give him a big round of applause. Now I invite Mr. Anand to deliver a keynote on the subject.
Friends, I have been asked to speak on jurisdiction of Supreme Court of India, that is one, and second, nature of practice in Supreme Court. So as far as jurisdiction is concerned, our court has the widest possible jurisdiction compared to any Supreme Court on the earth. So for example, US Supreme Court is essentially only a constitutional court. So only those issues either pertaining to statutes or state action which have bearing on the Constitution or require interpretation of Constitution, those issues alone you can raise before the Supreme Court. Whereas our Supreme Court is concerned, it is not only a constitutional court, it is also court having original jurisdiction in other areas as well as appellate jurisdiction. If you see the creation of Supreme Court and see the language of Article 124, it says there shall be Supreme Court of India. So it's not an enactment of Parliament which will prescribe the powers, etc. There shall be Supreme Court of India, just as there shall be High Court of every state. Article 214. So when you read Article 124 with other companion articles, then you will see that the Supreme Court's jurisdiction is a very wide network and it covers almost everything. Normally we think that Supreme Court would be concerned only with substantial questions of law, of general public importance, etc. But the range of jurisdiction is so wide that sometimes you see even the amusing things happening. For example, latest case where Supreme Court has already issued the notices whether we can tell certain jokes or not. So from one extreme we have a situation where they decide whether Parliament can amend the Constitution or not, and whether a particular Constitution is a valid, constitutional amendment is valid or not, and then you have discussion about jokes. Then there is also an issue, for example, which arose only 2 days back. Can you approach Supreme Court directly for a regular bail? Is that the scope of Article 136? Is it 32? What is it? So this is the first thing to be noted about our Supreme Court, that it is a court with very wide jurisdiction. This has created problems as far as working and administration of justice in the Supreme Court is concerned. For example, they still have matters which are pending for 7, 8, 9 years. So if you go on admitting all kind of matters, the arrears are bound to be there. This is also a thing which creates a positive side for a young lawyer who wants to join the Supreme Court bar and practice there. If any issue and every issue can be raised, then anybody can go and practice. We can all ask whether I can tell a particular joke or not. What's the big problem about it? Therefore, there are all kind of issues which are being debated. But since we have to cover a constitutional mandate, I would run through the constitutional articles which spell out the jurisdiction of the Supreme Court of India in its totality. First and foremost, as you know, is Article 32, which is confined to fundamental rights, that is rights arising from Part 3 of the Constitution of India. So, for example, under Article 226, High Court would have much wider jurisdiction compared to the jurisdiction of Supreme Court of India under Article 32. So, for example, take this bail issue. I'm just trying to keep it practical on connecting with day-to-day issues. If the bail raises the issue of violation of fundamental rights, then you may as well go there. Why not? It does appear that normally you would go for bail before a magistrate's court or sessions court or at the most high court. So if you are a lawyer practicing there, and if you can formulate your pleadings in terms of violation of fundamental rights, you can raise a question of bail as well before the Supreme Court directly. It is very risky, because once Supreme Court rejects your petition, where would you go? So it's not very wise to do it, but some people jump. So that is the first article. Remember it. Its jurisdiction is limited to fundamental rights, part 3. Then about 32, there is one thing I should tell you, which is not widely noted, that there is Article 33. Under Article 32, you can approach Supreme Court with the entire range of fundamental rights under 32. But 33 provides certain restrictions on fundamental rights of specific groups of people. For example, armed people, armed force people, they don't have fundamental right in the sense that we have. Can I, as a soldier fighting at the border, raise a question of Article 21 that my life is in danger? So as far as armed forces are concerned, or forces which are concerned with, say, telecommunications, there are 2-3 clauses. I am not going into everyone, but I am broadly indicating that if you have a case of a person of armed force or rendering certain telecommunication services or certain parts of infrastructure, Article 32 rights may be little bit limited. So you will have to examine that, whether you can file Article 32 petition in that kind of situation or not. Recently, when this question answer was going on, somebody raised this question regarding court of record. Under Article 129, Supreme Court is a court of record. Being a court of record has several implications. One was already mentioned by Asim Bhai and Percy. Namely, the record speaks for itself. You cannot question the record. That I argued this case and High Court has not noted, that is out of question. The other is that every court of record has innate power of punishing people for its own contempt. So every High Court and our Supreme Court is a court of record, and they have a power of contempt irrespective of the Contempt of Courts Act. That power flows from Article 129 itself, and the power of 129 means power of court of record, which means that is a power which is available both to Supreme Court as well as to the High Courts, but to no other courts. So for example, trial courts are not courts of record, though their record also speaks for itself as a matter of practice. But by constitutional mandate, Supreme Court and High Court are the courts of record, and this has these implications. Then there is Article 131, which is the original jurisdiction of Supreme Court of India. This is the jurisdiction where Supreme Court is like a trial court. Suppose there is a dispute between state of Gujarat and state of Rajasthan. For example, we have a Narmada Canal which is running through 4 states. And these issues have actually arisen in the South India regarding this Kaveri dispute, which is popularly known as Kaveri dispute, say between Tamil Nadu and Karnataka. So in those cases, you can't go to the High Court of respective state, because Article 214 says there shall be High Court for every state. So suppose Karnataka files petition on Kaveri dispute in Karnataka, and Tamil Nadu files a petition in Tamil Nadu High Court, that would be unworkable. Therefore, in such situations, the Supreme Court has a direct original jurisdiction where trial may take place. Of course, by and large, my experience has been that they go by affidavits only, because these matters are matters of documents and record. It's not as if Chief Secretary will enter the witness box and he will be cross-examined and all that. It's not like that. But that is an original jurisdiction, and that covers dispute between two states, disputes between Government of India and some state, and dispute between Government of India and one state on the one side and some other state on the other side. They are covered under Article 131, which is the original jurisdiction of the Supreme Court of India. Then you have Article 132, which brings into focus the appellate jurisdiction of the Supreme Court of India, where the High Court has the right and the authority to certify that substantial question of law arises and which is required to be considered or decided by the Supreme Court of India. This is not these days I have seen in the High Court practice that people do not resort much to it.